Okay, we are recording. Hi, good evening, good afternoon. My name is Jorge Rivera. I'm the Southern California Regional Coordinator with Tenants Together. Tenants Together is a statewide nonprofit coalition of members all throughout the state of California, and we fight for tenant rights. And we help folks like the Downey Tenants Union build their tenant movement in their respective cities. And we support other community groups like the Downey Tenants Union with any training, information, or education so that we can help inform tenants and help grow the tenant movement across the state. So welcome, I'm here to do a basic general tenants rights training. And I use the pronouns he, him, his. Maybe we can go around and everybody can just say who they are and maybe like how long you've been in Downey, how long you've been a renter, and why you're here tonight. So I'll pass it over to Rodolfo.
Right, well, thank you so much, Jorge. So my name is Rodolfo. I am a renter, and I'm all about this movement. I think it's really important. You know, here in Downey, we've been pushing really hard as we can, and we've gotten some extractions from the city government, but we need a lot more, and it's going to take a lot more people, and that's why we're here, and we're fighting, and we're getting ourselves educated. So thank you, Jorge, for being here with us and sharing your presentation.
Sure. Let's see. Alice, I hope would you like to introduce yourself? Okay, maybe there's having trouble connecting with the sound. Patty, would you like to introduce yourself? Ok, Efraín, ¿te quieres presentar?
Ok. Mi nombre es Efraín Naranjo Hernández. Vivo de Long Beach, California. Estoy en el grupo de recursos del pueblo, o sea, Centro de Recursos del Pueblo. Estamos de voluntario y es un placer para mí estar en esta reunión.
Okay. Gracias, Efraín. Efraín said that he is from Long Beach and he is with the People's Resource Center as a volunteer, and it's a pleasure to be here in this meeting. Let's try Alfredo. Would you like to introduce yourself?
Hi, can you hear me?
Yes.
Hi, everyone. My name is Alfredo Bañuelos. I'm from the city of Paramount. I've been collaborating a little bit with Rodolfo and Catherine with the Downey Tenants Union, and in the process attempting to organize and mobilize the people of Paramount in the city, trying to pick up what could be our own tenants union, and just here to learn. Once again, thank you, Jorge, for all the information you provide. I was in one of the previous meetings that Catherine held, and it was very useful, very informative. Thank you.
Awesome. Thank you. Thank you for being with us. Let's connect offline, you and I. Leslie, would you like to introduce yourself?
Hi, my name is Leslie, and I am part of Downey Tenants Union. I'm Catherine's neighbor. And yeah, I'm just here trying to educate myself a lot more than she has, because as you guys know, our apartment, we kind of went through a lot, and she helped educate a lot of us about rights that we didn't even know we had. And I would like to educate myself to get to the position where she is, where I can teach other people about their rights as well.
That's the idea. Excellent. And last, I know, Christian, it looked like you were driving. I don't know if you can introduce yourself, if it's safe.
Hello, yes, I am driving, but I am finally at my destination.
Cool. I think
My name is Christian Romero. I am a community member. Can you hear me?
yes.
Sorry, guys. So like most of you, I'm here to educate myself on how I can be supportive to my community and the people around me. And so this is the second meeting I attend. I hope to continue to attend these meetings so I can learn more. Therefore, I can, try to educate others as well.
Great. Thank you. Thanks for being here. Patty, giving you another shot to introduce yourself if you're with us? Or maybe we did get to Patty, huh?
I am here. I'm so sorry. I apologize, everyone. I'm part of Todos Somos Uno, California. We've been assisting tenants who have been illegally locked out of their house during the pandemic, and we've just been working also with Catherine, with Freddie, and with Rodolfo Cortez. And I'm here to educate myself about tenants' rights because I know there's a lot of need for legal assistance or just for questions regarding tenants' rights. And I guess there's not enough nonprofits or enough personnel to assist tenants during this difficult times.
Great. Thank you, Patty. Thanks for being here.
Thank you.
Okay. Well, we'll go ahead and get started. I'm going to share my screen here, and then we'll go through the presentation. What happened? Here we are. Okay. Can y'all see my screen?
Yes, thank you.
Okay. So this training is sort of general basic tenant rights. We will talk about the new law that started in January, AB 1482, a little bit. And again, these are your basic tenant rights. There's a lot of laws that are trying to be passed right now that might give you more protections as a renter. And hopefully those get passed. We can talk a little bit about what's happening right now with the courts and the sheriffs and evictions a little bit after the presentation. There's a lot to learn, and I can gladly share these slides with the Downey Tenants Union, and they can share them with you afterwards so that you have them with you as reference. And then just feel free to ask questions as we're going along. You can since there's a few of us, you can just unmute yourself and ask a question, or you can go ahead and type it in the chat, and then I'll try to get to it. But this training is from, I call it from move in to move out and everything in between. So we'll start with the very first slide, which is about renting an apartment and what you should know when you are renting an apartment. So when you're looking for an apartment to rent, you have to go around and apply. And as you probably know, there's always a fee for applying to rent an apartment. And as of 2020, the maximum amount that a person or a property management company can charge you for that rental application fee is $50 per person that is over 18 years of age. That's the max. And even though landlords are not supposed to profit off of that application fee, it's only supposed to cover the fees to be able to like run your credit and maybe some administration fees, right? And generally these fees are non-refundable. Now, if you want to make sure that they are actually running your credit and they're not just taking your money and telling you that you didn't get it, you can apply what is the Fair Credit Reporting Act. The Fair Credit Reporting Act states that if you are denied any type of service, which renting an apartment is, based on your credit, then you are entitled to get a copy of your credit report. So if you want to make sure that they're actually using the money to run your credit, if you get denied, you can request a copy of your credit report, and they have to, by law, provide it for you. If they don't provide it to you, then that might give you a hint that they actually didn't even run it, okay? And then you can try to just advocate for yourself after that. So let's say that you got the apartment. Now it's time to talk about a contract, or talk about what's also known as the lease, right? There's two main types of leases. There's a fixed term lease, and then there's a month-to-month lease. All right, a fixed term just means that it's a fixed period of time. You usually hear about them as like 1 year, and those fixed term leases may or may not convert automatically to month. So at the end of the 1 year term, if the contract says that it will convert automatically, then you don't have to worry about renewing the lease. They don't have to renew it for you or approve you again. It's written in the contract that it will automatically convert month to month. But that's important to note. If you are getting into a fixed term lease, read the clause to see if it automatically converts, because if it does not automatically convert, then it is expected that you are going to be out of the apartment at the end of that lease. And because it's already written in the lease, the property management company or the landlord does not have to notify you that you have to be out, right? So they don't have to give you a 30-day notice or a 60-day notice if it does not automatically convert. The expectation is that you're going to be out at the end of the term. The most common form of lease is the month-to-month lease, right? And with a month-to-month lease, you don't have as much protection as a fixed-term lease. A fixed-term lease allows you to stay within those terms for the period of time that it's for, and they can't, unless it's written in the contract, they can't raise your rent, or they can't just automatically evict you with a 30-day notice, because that would be breaking the lease. But a month-to-month lease doesn't have those type of protections, and so they just have to give you the appropriate amount of notice if they want to get you out or if they want to raise your rent. So a fixed term lease is always safer. It's more protective than a month-to-month lease. So you can always negotiate for a fixed term lease when you are applying. And when you're applying, sometimes committing to a fixed term lease is more attractive because they know that they're going to have a guaranteed tenant for a certain amount of time, right? And month-to-month lease, just like they can ask you to leave, you can give your notice to leave at any time, and it's not as secure for them. Now, we also hear that there are written versus oral leases as well, or verbal leases. And these are legally binding. The oral agreements are legally binding unless it's been over 1 year. And they're also really, really difficult to prove in court. So we're always recommending that you get a contract in writing at all times, just to protect yourself as a tenant. So another thing about the lease is that a lot of people don't know and don't advocate for is that you can request the copy of the lease, or to give you, before you sign it, a copy of the lease in the language of your preference, right? So according to California Civil Code 1632B, you can request in any other language a copy of the lease before actually signing it, so that you know exactly what it is that you're signing. If you're renting federally subsidized housing or Section 8 housing or anything like that, it's automatic by law. They have to give you a copy of the lease in the language of your preference. Let's say that you signed the lease, you got a copy, but you misplaced it and you lost it, or they never gave it to you. They never gave you a copy after you signed it. So you can request a copy of your lease one time per year, and by law, they have to give you a copy once you've requested it within 15 days. And if you request a copy of the lease, let's say in Spanish, then they have to also provide you a copy of the lease in the language that you've requested. Okay, so if they ever tell you that no, they don't have it in that language, that's just a bunch of lies, it's a bunch of BS. They have to provide it if you request it. So, and every time I mention you requesting something, I'm always talking about you requesting it in writing, not verbally. Okay, so whenever you're making any kind of request, it should always be in writing. And a little bit later in the training, we'll talk about how to do that properly. These are just
Question, Jorge.
yes.
What's the recommendation for when the lease agreement is over, meaning, or the term for the lease is over? I know that a lot of tenants have fear of bringing up the issue due to, I don't know, just fear of being told to evict or to bring up the subject. But what do you think is a recommendation? How should people go about it?
Well, I think if it's first, my recommendation would be first read the lease to see if it automatically converts to month. If it does automatically convert, they don't have to worry about renewing the lease. If it does not convert month to month, then they do have to try to get them to renew the lease. Otherwise, as soon as the term is over, the property management company or the landlord can then immediately start eviction proceedings, right? Without having to notify the tenant that they're starting it, because it's assumed that the tenant knows that the lease is coming to an end and that they have to be out of the unit. So I know it's scary and people get nervous about doing that, but avoiding it doesn't help the situation. They should definitely confront it and approach it if they have a lease that does not convert month to month. Okay. So this slide here just talks about like some of the terms that a lease normally contain. And another thing that a lot of folks don't know is that everything in a lease, everything in a contract is negotiable. Only because they have a pre-printed contract does not mean that you cannot negotiate it, right? This is a contract between you and the property owner, right? And you and the property management. And so it's just between two people, and everything in there can be negotiated. So only because they give you a template, like a contract, doesn't mean that you can't ask or make requests for something different, okay? All right, so let's say you got the lease, you signed it, and now you're about to move in. So the really good, reputable companies, they will do a move-in inspection with you. If they don't do a move-in inspection, it is always recommended that you as a renter do your own move-in inspection. So before you start moving everything into the unit, go into the apartment, take pictures of everything, take videos if you have to, test the water faucets, test the toilet, test the heater, test all of these things, and make a list of everything that you think that is not working properly or that needs fixing, right? You can Google a move-in checklist and find a checklist online, or you can just take a plain piece of paper and make a list of everything that you think needs to be fixed or needs to be repaired, right? And so you have your pictures, you have the list, make sure that your list has your name, your address, and your unit number, and get the pictures and the list, sign and date the letter, make copies of them, and then put them in an envelope and send it to the management company via certified mail only. Don't ask for a return receipt because they will never sign for it, and then they can claim that they never got it. So certified mail is about $3.40 to send certified. You get a receipt from the post office telling you when they delivered the letter, and that's all that you need. You don't need them to sign for it, okay? So just send it certified mail. You don't need them to sign. Let's see. Okay, they're ASL interpreters. Okay, so, all right, cool. Thank you, Risa. Next slide. Okay, so all of this, oh, I don't need this. All of this is really important to protect your security deposit. So many people lose their security deposit because they're not doing a move-in checklist or a move-out inspection, right? Where is the ASL interpreter, please? Let me see. I guess Susan Gonzalez is requesting ASL interpretation. Okay, there they are. Okay, so let's go into security deposits, because this is like your money, not their money. So usually you have to pay a security deposit, right? And a security deposit can be used for past due rent if you leave and you owe rent, or if you damage the property beyond normal wear and tear, right? So there is wear and tear on the property that is normal and that you are, as a tenant, are not responsible for, right? This is why it's important to take pictures when you move in and then take pictures when you move out, so that you can compare the two, just in case they're claiming that you caused damage beyond normal wear and tear. And then just leave the unit clean as you found it. It is usually referred to as broom clean condition. So as long as you leave it in that state, then you should be good. Included as part of the security deposit, they can use it for key deposits, cleaning fees, new tenant processing fee, or a pet deposit. Sometimes when you have a pet, they ask you for a security deposit and a pet deposit, right? And so people think that they're two different things, but you'll see in the next slide when we talk about the maximum that they can charge you, you have to think about them as the same type of deposit, okay? Even though they call them two different things. Okay, so what's not included in the security deposit is your rental application fee that you paid when you applied. So according to the law, if you are renting an unfurnished apartment, meaning there's no furniture in there, the maximum that they can ask for is 2 times the monthly rent. So for example, if the monthly rent is $1,200, the most that they can ask for a security deposit is $2,400. And again, that includes the pet deposit. So they can't charge you $2,400 and a pet deposit. The pet deposit is included in that maximum amount. If you happen to rent an apartment that it already has furniture, then they can charge you up to 3 times the monthly rent. And other things, security deposits can be increased, right? A lot of people don't know this because we don't see it very often. But if they raise your rent, then they can also raise your security deposit. As long as they're not charging you more than 2 times the monthly rent, they can raise your security deposit. And they have to give you appropriate notification that they're going to do so. They can't raise your security deposit if you're in a fixed term lease, right? So again, a fixed term lease gives you more protection than a month-to-month lease. So if you can get into a fixed term lease, it's better for you. So in protecting your security deposit, be sure to complete those checklists. Give proper notice that you're moving out. If you're going to move out, I think you have to give 30 days notice, and make sure that you schedule a move out inspection before you actually move. Security deposits have to be refunded or accounted for within 21 days after you have moved out of the unit. So a lot of people expect that their security deposits are returned immediately after they move out, but they have 21 days to actually get it to you. The security deposit can be deducted if you owe rent, if you left the apartment less clean than when you found it, or if they are claiming that you damaged something in the apartment beyond normal wear and tear, or if they charged you for keys or furniture and you don't return them or you damage them. So let's go back to beyond normal wear and tear, right? So if you've lived like in an apartment for 7 or more years and they never changed your carpet, and when you move out, they claim, oh, we have to use your security deposit to change the carpet. That is not normal wear and tear. That is not beyond normal wear and tear. 7 to 10 years is a reasonable amount of time where if you've been living there that long, they should have probably changed the carpet by then. If they have to paint the unit after you've lived there for about 7 years, is like they can't charge you for painting the unit because that is considered normal wear and tear. So it's important to hold property management companies and landlords accountable to account for why they are not returning your security deposit. There is a standard, I think $125 that they can decrease for cleaning fees, but that's pretty much it. If the unit is still in good condition and there is no damage that you caused, they should be turning the rest of your security deposit if they want to hold on to that cleaning fee. I'm hearing some background noise, so if y'all are out and about, please be sure to mute yourself. Thank you. If the security deposit is not returned, then you have to request in writing that they either return your security deposit or give you an itemized list as to why they're not returning it. And every time you send a letter, send it the same way via certified mail and make sure that you make a copy for yourself. If after sending the letter, they still don't return the security deposit, then the next step is taking them to small claims court. You have a computer.
Jorge, quick question. So in violation of the security deposit laws, should it go to small claims, such as when they withhold it?
Can you repeat that question?
Sure. So for example, say I got charged 4 times the amount of the monthly rent, which would be illegal in both the scenarios that you painted, right, the furnished or unfurnished. If such violation were to occur, is the way to recover that money or to call out what happened small claims court, or if that's just the way the landlord chooses to do business?
So in that scenario, if you got charged way more than they're allowed to charge you for security deposit, then I would write them and ask them to refund that money based on that civil section code, right? And then if they don't, then taking them to small claims court would be the next step. And just so that you know, small claims court is really, really simple. It's just you and the owner. There's no lawyers. It's just you, the owner, and the judge. It costs about $75 to file a small claims lawsuit, and maybe like 25 or some more money to actually have somebody serve the property owner with the summons. And usually small claims court are favorable to tenants, and it's usually a no-brainer when it comes to security deposits. I've taken my landlords to court twice, and I've won twice. You know, just because they're trying to keep my money and they have no foundation to keep my money, and so I've taken them to court and won both times. So it's really simple. And there's only like a one-page application to file a lawsuit.
That's good to know, because I know there's so much intimidation and fear from tenants. Also, so the way to request that refund or let them know they're doing something out of the law is still through a registered mail, right? A letter like you recommended previously, or?
Yes. Yeah, certified mail.
Certified mail, okay. So
Yeah.
always do that.
George, I wanted to share that courts sometimes, for low-income families, they don't have to pay for the court fees.
That's right. There are fee waivers for small claims courts if you are a certain income level. So you can always apply for a fee waiver, and it doesn't cost you anything. That's right. Okay. So now let's talk about rent and rent payments. So you have to pay rent on the due date as stated in the contract. Usually some contracts allow you for a grace period of like 3 to 5 days, and that's pretty normal. Now, late charges. A lot of people don't know this about late charges. So a late charge cannot be a punishment to the tenant because they paid their rent late. A late charge has to be justified by some reasonable estimate of a cost that the property owner incurred because you paid your rent late. So for example, I'm a property owner and I have a mortgage loan on my property that I have to pay every month. And I rely on the rent that comes in so that I can make that payment. If I pay my mortgage late, then there is usually a fee that I have to pay because I paid my mortgage late. So then I can charge that fee to my tenants because they didn't pay their rent on time. That's why I was late. That is a justified penalty, right? Because I have to pay a late fee, so I'll pass it on to my tenants. I can't, as a property owner, just because you paid your rent late and I didn't like it, and I'm going to charge you $75 because you paid your rent a couple of days late. That is a punishment, and it's not allowed by law, right? When you go to eviction court and you have an attorney, one of the first questions that they ask you is, did they charge you late fees? Because they know that they'll be able to recover all of the late fees that you paid, because most of the time, those late fees are just an amount that they made up and they put into the contract, right? And so as a tenant, what you can do when you've signed a lease agreement and they're charging you a late fee, you can demand that they justify the amount of the late fee and why they're charging that amount, right? Because you have the right to know what's the late fee for, you know? And a lot of people just pay the late fee because they're scared that they're going to get evicted. Another thing that you should know about late fees is that it's not part of the rent payment. So they really can't evict you because you did not pay the late fee. They can only evict you if you didn't pay rent. But they can't evict you because you refuse to pay the late fee. They can try to take you to small claims court to get the late fees back, but it will probably cost them more money than it is that they're trying to collect. So, but they will scare you and they will tell you that they're going to evict you, or they'll give you a 3-day notice to pay or quit because you didn't pay the late fee. They'll do everything to try to get their money. But you should know that they cannot evict you because you didn't pay the late fee, okay? As far as partial payments, the property owner does not have to accept a partial payment. If the property owner does agree to accept a partial payment, then be sure that you get that in writing, right? That there's an agreement. It's like, okay, I'm going to pay you half now. I'm going to pay you half the next day. You know, sometimes that has to happen, but they don't have to accept it if they don't want to. And just so you know, the property owners cannot require you to pay cash or to pay by some online form of payment, right? They can ask or suggest that you pay in these other ways, but they cannot require it. And it's actually recommended that you never pay in cash, right? Never pay in cash, always pay in check, money order, or cashier's check, and always request a receipt for payment. Even though you get a copy of your check on your bank statement, still always request a receipt for rent payment, and you are legally entitled to get one. So if they tell you, no, we don't give out rent receipts, that's just a bunch of BS, and they have to give you one. Utilities, sometimes in the rental agreements, they will specify what utilities they're going to cover and what utilities you as a tenant are going to have to be responsible for. If you live in a property where you have shared meters like a gas meter or a water meter, then they have to divide it up equally amongst everybody. Shared meters is really sometimes causes a lot of problems between tenants because one tenant might use more water than another, and so on and so forth. Unfortunately, yes.
Sorry, I have a question.
Mm-hmm.
So this is what's going on in my complex pretty much. The new tenants, they sign a lease and they are paying for water, but they don't have a meter on it. And it doesn't specify in the agreement that they need to pay this amount of percentage off. They're just giving them like, oh, this is what you have to pay. So I want to know if that is okay, that is not okay. Can I send a letter to them and let them know, you know what, you guys don't have a meter for this is unlawful, you know, like it's not okay.
Yeah, they can, and I would recommend that they always, if they think that it's unlawful, or yeah, if it was written in the lease though, it's gonna be tough if they signed it. If they signed it and they agreed to it, it's gonna be harder to try to go backwards from that. But I would still try. There's no harm in trying. Then. Because again, they can always renegotiate the lease and request that they remove that clause and sign a new one. So I would still write a letter saying, hey, how are you justifying this amount? How are you making your calculations? I don't think that I'm using this much water, and I think that this cost is too high. So water is really unusual, because water is usually something that the property owner takes care of, you know, as part of their cost. But in some cases, they do charge it to the tenant. Okay, so now you're living in your property and you have a whole bunch of issues and you need to take care of them. So how do you go about doing repairs and maintenance? So to start with, the law says that a unit should be habitable to live in. That means that it is fit for occupation by human beings and substantially complies with state and local building and health codes. The apartment should be free from all of these things and many others, right? You should have adequate hot water. You should have smoke and carbon monoxide detectors. There should not be any leaks on the ceilings or the walls. There should not be holes in the floors or carpet. You should, even though we live in California and it's hot most of the time, by law, you have to have a working heater, right? It has to be working. If not, it's a code violation. You should not have any missing or broken windows or screens. You should not have any infestations of rat, roaches, or insects. They should make sure that they're collecting the trash, because if they don't, then that'll bring rodents or other insects. And if you have security doors on the building, all of those security doors and locks should be working. And the wiring in the apartment should also be covered and not exposed. And then if you have stairs, the stairs should be fine. The rails, the handrails, they should be working fine. And anything else in common areas should be in good condition. So if it's not in good condition or you need to get repairs, it's so important that you're always documenting this and you're putting this in writing and you're sending it to them in a letter, because it's the only way that you're going to prove it later on if you have to go to court for it. So always request repairs in writing. And I've listed the different ways that you can do that in the order of preference. So my preferred way is always in a letter. Just like you did the move-in checklist, list all of the repairs that are needed, take and include the pictures, sign, date, and make copies. Make sure that all of your information is on that letter, your name, your address, your apartment number, and then send that letter certified mail so that you have proof that it got delivered. Some property management companies have online systems where you have to input a request for repairs. If you have to do that system, always take a picture with your phone or take a screenshot before you submit it. The reason why I suggest that is because when my partner was living in another apartment, somebody threw a rock through the window, and they had an online system where we had to request repairs. We submitted the request. We waited a couple of weeks. We never got a phone call. And then when we went back into the system, it wasn't there anymore. And so they claimed that we never made the request. So always make sure that you take a screenshot or a picture of it. Email is okay only if that email that they are using is a work-related email. If it's a Gmail or Yahoo or AOL or anything else, it's debatable, because they can always claim that they never got it if it's a personal email address. But if it's an account that they use, like Jorge at tenantstogether.com, tenantstogether.com is our work website. So that's a work email. So if it has the name of their company or it has something like that, that's fine. But if it's not, if it's a Gmail account, then I wouldn't trust it. So I always prefer in letter, good old-fashioned letter. Once you make the request, you have to wait a reasonable amount of time. And the question is, like, what is a reasonable amount of time? If it's not an emergency, then the state says that a reasonable amount of time is 30 days for them to actually make the repairs, not to respond, but to actually make the repairs. But if it's an emergency, like you have a pipe that's busted and it's squirting water everywhere, that's something that they have to respond right away to. And that's something that you will be able to write a letter for. That's something that you have to call them, document it, that you made the phone call, but have them come out right away. If it's like a non-working toilet, I don't think you can wait 30 days for a toilet that's not working. So you may want to tell them is that you need to come in like 48 hours or whatever amount of time. But always specify what you expect them to respond in terms of time. If you send the letter and they still don't respond or they don't come out and do the repairs, then the next step is to call the health department or the city's code enforcement department. So when you call the health department or the code enforcement, they will send somebody out to do an inspection. When they do an inspection, they will then create a report of whatever it is that they found. And you can get a copy of that report to be able to use it if you have to go to court. That report is really important because it's a third-party report, and it's usually from a government agency. And when you take that report to, say, court in front of a judge, it just makes a big, big difference, right? So if they are not responding and making repairs, call the health department, call the code enforcement, and make sure that they're coming out and doing an inspection. The law states that you have two options when you're asking for repairs, right? If after calling the health department and the code enforcement, they're still not doing anything, the law says that you can either repair it yourself and deduct it from the rent, or you can withhold the rent 100%, right? Now, the only thing that you have to do in order to enforce these two rights is that you have to let the property owner know that this is what your intention is. So, for example, when I write a letter for a tenant requesting repairs, the very first time, the very first letter, at the top of the letter, I always tell them with the intention to withhold rent. So the title of the letter is requesting repairs with the intention to withhold rent. So now I'm notifying the owner that if you don't do this, then I am going to enact my right to withhold the rent 100%. If you don't feel comfortable doing that, you can always say, with the intention to repair and deduct. Then you can make the repairs yourself and deduct that cost from the rent. If you do the repair and deduct, the value of the repair has to be less than 1 month's rent. So if your rent is $1,200, you can't do repairs that are more than that amount. And you can do this 2 times in 1 year. So if there's multiple repairs that need to be done, you can do some repairs 1 month, and then you can do the rest of the repairs the other month. As long as you're letting them know that this is what you intend to do, if they don't do anything, you have every right to do one of these two things.
I have a question in
Yes.
regards to that.
Mm-hmm.
Just briefly, if the landlord does not appreciate the repair that's done into the facility, can they take you to court or engage in any legal litigation because of it?
So if they think that the repair that you done was not good, is that what you mean?
Yes, like if they have any sort of problem, maybe they didn't like it, they didn't feel it was up to standard, or it infringed upon a different approach that they wanted to take.
So if you notified them that you were going to repair it and they did nothing about it, then there's not much that they can say. But if you did repairs on your own without notifying them, and they think that it brings the value down or it makes the property less rentable, then they might be able to take you to small claims court and try to get the difference. I mean, they can try. I don't know. It must be really, really bad repairs that you did in order for them to win something like that. But they can always try. That's why I always recommend notify them that you're going to do it, because if they don't respond after you've told them that you're going to do it, then they can't say much because you told them and they didn't respond. So if they don't like the quality of repairs, they should have responded, right?
Jorge, I have a question.
Okay.
So I understand that for, well, with what you're talking about, there's also specific rules for disabled people and reasonable modifications or accommodations requests. What is the law that stipulates that? Is that the I forget what it's called. Is that the Disabilities Act, or
Yeah.
could you talk a little bit more about doing a modification for someone disabled, say like a ramp or something like that?
Yeah, I'm not very fluent on disability rights when it comes to reasonable accommodations, but I can definitely find out for you. There are like certain levels of modifications that go beyond what a landlord or property owner is able and should do, but there are some simple things like a ramp, or like some rails in the bathroom, or things of that sort. What I've heard in certain instances is that a tenant can make those modifications if they need it inside the unit, as long as they return the unit when they move out to the same condition that it was in before. So if you needed like handles or handrails in the shower or in the bathroom, like you can install them, but then when you move out of the unit, if the landlord thinks that depreciates the value, then they can request that you return the unit back to its original form. But again, I'm not very fluid on disability rights. I know that folks have been successful in requesting reasonable accommodations, and it can be done. But if it's a really large modification, then I would probably seek legal counsel on that. So the last choice that you have is you can always repair things in your unit and then take the property owner to small claims court and sue them for the amount of money that it cost to do the repairs. So you have three choices in being able to make repairs. Okay, retaliation, because a lot of people are scared about requesting for repairs because they're scared that they're going to be seen as a nuisance or a complainer, and they don't want to get their rent raised, or they don't want to get evicted, right? So California state law says that once you make request for repairs in writing, if the property owner tries to raise your rent or evict you within 6 months, which is 180 days, this is considered retaliation and it's illegal, right? So just so that you know that the law protects you if you make requests. This is why I think, again, going back to the importance of putting it in writing. You know, verbal requests are really hard to prove, especially if they start to retaliate against you. How are you going to prove that you actually made those requests, right? So you can't really claim retaliation because there's no documentation that you actually made requests. So always try to put it in writing. Letter is the best form. email is the next best form. Okay. And now with the new law that went into effect in January, AB 1482, if your property is covered by AB 1482, then they can't evict you just because you requested repairs, because requesting repairs and maintenance is not a valid reason for eviction under this new law, right? So if you are protected under AB 1482, requesting repairs is not a valid reason. It's not what we call a just cause, okay? So when you're living in a building like the building that Kathy is living in, you know, when we organize buildings, we always tell folks is like, it's safer to do it together because you have more collective power if it's everybody that is having the same issues and they all write one letter all together and they send that to the property owner. Efrain is a tenant that I worked with in Long Beach, 17 units. We wrote one letter for all 17 units and we sent it in to show the property owner that you are all united and that you are all sticking together and that you are all making these requests, right? So we always recommend that you organize your neighbors and write one letter for everybody that wants to be on that letter.
I have a quick question.
Mm-hmm.
Just in regards to that, I know that any individual can probably submit a letter, but just for court optics, what would be a good number that an organizer should strive for when trying to build up a letter? What's a good number of people to accumulate?
The more the better. The more the better. I mean, it's like 50% is always an ideal number. So if you have 6 units or 50 units, you know, if you can get 50%, that's really, really good. So I would shoot for that.
Thank you.
Okay, so let's talk a little bit about rent increases. So when you get a rent increase, the law requires that you get at least 30 days notice if it's less than 10%, and 60-day notice minimum if it's more than 10%. Now, because of this new law, AB 1482, if you are covered by it, then your rent cannot be increased more than 5% plus CPI, which is the rate of inflation, per year. Because the economy is doing really, really bad right now, in LA County, that rate of inflation is like 0.7%. So 5% plus 0.7 is 5.7. So the maximum that they can increase your rent per year, if you're covered under this new law, is 5.7%. They can split it up, like give you 3% increase this month, and then a few more months later, give you another 2.7% increase, as long as it does not add up to the maximum that they're allowed to charge you by law. So because that increase is less than 10%, they only have to give you 30 days notice, right? So how you receive the rent increase notice is really important. It has to be in writing. It has to be delivered to you properly. It has to have the correct dates and the amounts of the notice. And the time starts when you receive the notice, not when the notice was dated, right? So for example, if you receive the notice on August 10th, but the notice is dated August 1st, the 30 days doesn't start until August 10th. It doesn't start on August 1st. right? So when you got the notice is when the time starts, right? And if it's not delivered correctly, then it may be considered insufficient notice. So they usually mail it and post it to your door. Sometimes if they only post it to your door, that is not considered sufficient notice. They also have to mail it. So how they give it to you is also important. If they give it to you in person, in your hand, with somebody over 18 years old, there's no way that you can deny that you received it. So that is also proper notification. So let's talk about all the different types of notices that you might receive. So there is a notice to vacate, which is also like a termination of tenancy notice, or notice to move out. There's all different names for this type of notice. Basically, it's asking you to leave, right? So if you've lived in your apartment for less than 1 year, then they only have to give you a 30-day notice. If you've lived in your apartment for more than 1 year, they have to give you a 60-day notice. And 90-day notices are only for properties that are in foreclosure or are government subsidized or Section 8. Some landlords in some rare circumstances will give you a 90-day notice if you're not Section 8, but that's not typical, right? The same thing with every other notice, it has to be in writing, it has to be delivered properly, it has to have all the correct information on it, and the time starts once you receive it. Now remember that if you're in a fixed term lease and it does not convert month to month, they do not have to give you a notice that you have to be out. Most people do, but they don't have to give it to you, right? So if you never get a notice and the lease term ends, it's expected that you're going to be out on that day, okay? So the new law, AB 1482, if your unit is covered by it, they can't evict you for just no reason anymore. They have to have a just cause. And a just cause is a list of reasons why they may be able to legally ask you to vacate. So, a good reason is you didn't pay your rent, or you were doing something illegal in the unit, or you violated a term of the lease, and things of that sort. There are 4 other reasons under this new law that are called no fault evictions, meaning that it's no fault of the tenant, but they can ask you to move. Some of these reasons include if they wanted to move an immediate family member into your unit, like a brother, sister, mother. It has to be an immediate family member. They can ask you to move. Or what we are seeing a lot, what we are calling renovictions, is that if they wanted to quote unquote renovate your apartment and they have to ask you to move out, then they can ask you to move out. They have to do renovations to the extent that they need to get a building permit from the city. So it can't just be, oh, we're going to paint, because you don't necessarily need a permit from the city to paint. But if you're going to be tearing out cabinets and sinks and plumbing and all this stuff, then they have to get permits for that. So their renovation has to require a permit. And unfortunately, in certain cities, they don't have to prove that they are actually getting these permits. Like in the city of Long Beach, they passed an ordinance that requires property owners to get their building permits first and approved before they can even ask a tenant to move out. right? Like in the city of Downey, that's not a law that exists. So a property owner only has to tell you, we're going to renovate the apartment. That's why I'm asking you to move, right? So just to give you some ideas of some laws that you might be able to advocate for to strengthen AB 1482. And if you're not covered under AB 1482, it is still the case that property owners don't have to give you a reason why they're asking you to leave. Okay, so always try to investigate whether or not your unit is covered by 1482.
On that, Jorge, how do we find that out? How do we, or who exactly is covered by 1482 and who's excluded?
Good question. And hopefully we'll get to that later on down the line. Is that cool?
Yes, absolutely. Thank you.
Okay. So what we're seeing a lot is a lot of illegal lockouts and utility terminations, especially right now during COVID. A landlord or property owner cannot interrupt or terminate your utility services just because. If they can also not lock you out or prevent you from accessing your property just because. And so we're seeing property owners changing locks, removing doors, removing people's belongings, and putting them out on the street. They can't do any of this stuff unless they've gone to court. So one remedy, if this happens, is you can choose, if you feel comfortable, you can choose to call the police, and you can also sue the property owner in small claims court at the tone of $100 per day for every day that they've turned off the utilities or every day that you've been out of your apartment. Or you can get an attorney and file for what's called injunctive relief, which will immediately tell the property owner that they have to stop. Okay. So 3-day notices, there's 3 types. 3-day notice to pay rent or quit. Again, this is for rent, not for late fees, but they will give you notices if you don't pay your late fees, a 3-day notice, trying to scare you into paying your late fees. Okay, but it's just for rent, not for late fees. A 3-day notice to cure or quit. So this is if you're violating a lease term and they give you a warning, they'll give you a 3-day notice. It's like, hey, you have to fix this or you have to stop this. Otherwise, we're going to start with evictions. And then there's just a 3-day notice to quit. So if you did something that is not repairable, you did unlawful activity or something like that, or you were you were, I guess, the perpetrator of domestic violence, they can kick you out with the 3-day notice to quit. No chance of making any amends. And now with the new law that was passed last year, the 3-day notice does not include holidays or weekends. So if you get the notice on Friday, it's still Monday and Tuesday to complete the 3 days. So they have to give you a 24-hour notice to enter. This is for every other reason except for an emergency. And or if you've requested repairs and they agreed to do the repairs, they just have to give you 24 hours notice to enter the apartment. This has to be a full 24 hours, okay? I see property owners give a 24-hour notice at 6 p.m. to come into the apartment at 9 a.m. the next day. That's not 24 hours, right? So you as a tenant can say, this is not valid notice. I do not allow you or give you permission. You have to give me a full 24 hours notice, okay? So that just that you know. And these are some of the reasons that they can come into the unit for an emergency, or if you left and abandoned the apartment, or they have to come in and do repairs, or if they're showing the unit to prospective seller or a buyer, or another tenant. And so as far as coming into the unit, they have to come in during normal business hours. If you give them permission to come in on Saturdays and Sundays or at night, then that's up to you. You can totally say that it's okay. If you have to go to work and you want to come home and be there when they do the repairs and they want to come in at 7 at night, you can tell them that that's okay. But just so that you know that your rights are that you can ask them to do this during normal business hours between 8 and 5, not including the weekends. Other notices, if there's a change in ownership, the law requires that they have to notify you of that change within 15 days. Eviction notices. All right, let's talk about an eviction notice. So an eviction notice is also referred to as an unlawful detainer. Okay, so the 3-day notice, the 30-day notice, the 60-day notice, those are just notices. They're not eviction notices according to like the legal terms, right? So an eviction notice by law is the summons and complaint that you receive from the court after the owner has filed for an eviction, right? And it's usually called an unlawful detainer. So some facts that you should know about unlawful detainers: it is the only legal way that they can get you out of the apartment. There is no other way legally that they can remove you from an apartment other than an unlawful detainer. Okay, it's a lawsuit against you because they're claiming that you're still occupying a property that is theirs, and they can file this at the conclusion of a fixed term lease that does not convert, or they can file it after they've given you a 30 or 60-day notice or a 3-day notice to quit and you're still in the unit. The actual eviction process can take anywhere from 1 to 2 months, maybe even sooner if there's not a lot of cases. But there always has to be written notice prior to the eviction. So if they never gave you a 3-day or a 60-day or a 30-day notice, and then all of a sudden you get court papers, it's like that is not a lawful process, right? So they can't just automatically go to court and file for an eviction if they never gave you any other notice before that. Now that's what the law says. And I always tell people that only because the law says one thing does not mean that they're going to abide by it. Just like the speed limit says that it's 65 miles an hour, that doesn't mean everybody's going to pay attention to the speed limit. You know, people are still going to go over the speed limit. The same thing with property owners and management companies. Only because the law says one thing doesn't mean that they're not going to try something else, okay? That's why it's important for you to learn this so that you know when they try something and it's not legal, you can push back, right? So the basic process, an eviction, is the property owner goes to court, files a complaint, the court issues what's called a court summons, and then the court summons is then sent to you. Usually the property owner will post a copy of it on your door and might even mail it to you. And also the court will send you a copy to notify you that somebody has filed an eviction case against you. Then once you receive that notice, you have 5 days to respond to the notice. And 5 days does not include weekends or holidays anymore. Susan is asking a question. Please talk about eviction process during pandemic. protections ended, so now evictions are on the rise. What are the rights protections here? Okay. Okay, let me finish this slide, Susan, and then I'll talk a little bit about that. So you have 5 days to respond, and we always recommend that you get an attorney to respond, right? Because an attorney will fill out the response in such a way that will be in your favor if you go to court. And we recommend, as well as attorneys recommend, it is your right to request a jury trial when you respond to these eviction notices. And we suggest that you always request a jury trial, right? And then once you do the response, you wait for the court to send you a court date, and then you go to court, and it's you, and if you have an attorney, your attorney, and then them and their attorney. And 95% of the cases that go to court reach a settlement without having to go to trial, right? If you go to trial and you lose, then you'll have a judgment against you, and that is when they might report it on your credit report. So as far as evictions during COVID, there was a body of people called the Judicial Council, and they are not a government agency. They're not part of the government. They just sort of oversee and manage all of the courts in California. In April, they passed something that was called Rule 1 and 2 that basically told the courts, don't process any paperwork for any filings of evictions. So a property owner can go to the court, file a complaint, but then that's where it stops. It does not process and turn into a summons, and then it's not delivered to you. There's not a court date. There's not a trial date. There's nothing. It just stops at the complaint. That rule is now being lifted on September 1st. So beginning September 2nd, the courts will once again start to process the paperwork. So all of the complaints that have been filed between April and September, they're going to start to get processed. They will issue a summons, and then people will have to start going to court and responding to these summons and all this stuff. This is what people are referring to as the eviction tsunami that is coming, because there's going to be a lot of people that might be receiving these, and we are trying to prepare as best we can with all of the lawyers that we work with to be able to provide services to people. Okay, but that's the only difference now during COVID, during an eviction. There is no other difference that exists. We are organizing and trying to push our political leaders to pass additional protections to help us to avoid this tsunami. So hopefully that happens, but we have to continue to organize and push.
Jorge, a couple of questions about the previous slides before you move on. May I?
Yeah.
One, could you talk about the involvement of police officers in all of this? I understand that sometimes the police will side with the owners or aren't quite as informed as you'd expect them to be, empathetic. What do you say about involving the police in these matters for lockout or something like that, or cut out of utilities?
You know, we so there are two different differences of opinion with involving the police, especially with everything that's going on today with police brutality and defund the police movement, right? And I totally get it that some people do not feel comfortable involving the police, do not want to rely on the local police, right? So the only law enforcement that should be involved in an eviction is the sheriff, not the local police department, because it's a civil matter and the local police department should not be involved in any way, shape, or form with an eviction. If there's an illegal lockout, then it should be up to the tenant to decide whether or not they want to call the police. That's how, as an organizer, I would treat it, right? It's not my apartment, but if I'm going out to somebody's apartment and trying to advocate for them, I would ask them, do you feel comfortable calling the police? Do you want me to call the police? Because when the police show up, I can always try to educate the police on what the law says. You know, and you're right, there are some police officers that take the side of the landlord or the property owner, which is why some people don't feel comfortable calling the police. All right, but the local police should not be involved in any type of disputes or should not be taking the side of the property owner, especially if the property owner is involved in doing something illegal. That's when I would recommend that you just have to get an attorney and then try to advocate for yourself with their help.
And that was my second question, or at least that was regarding that. The response, you mentioned that it was best to consult with an attorney and have them go ahead and write up that response. What are the costs for something like that? And if it's too much, what are the alternatives?
Well, it depends on the attorney. There are some nonprofit organizations like the Eviction Defense Network or BASTA that they charge a flat fee for representing you from the beginning to the end, right? So there's no like fee up front for them to file a response. There's just an overall general fee to cover you. They will help you write the response, but they'll also represent you in court, right? And then there's other for-profit attorneys that might charge a little bit more. You can try to file the response yourself by going to the self-help centers at the courthouse, but they don't always recommend what's best and in your favor. So there is an application that somebody is designing right now to try to help tenants respond to unlawful detainers electronically. And it would be free, and it would file all the paperwork that you need just by answering a few simple questions. We're hoping that they have this application done by September 1st, and it will be available for all of LA County. And I'm sure you'll hear about it. I'll share it all out to everybody if it gets online. Okay, so the next slides, it just goes over the basic eviction process, just kind of like what I already laid out. So you'll get a copy of these slides so that you can go through them step by step on your own time. So things to know about notices and evictions. If you are still in the apartment after getting one of these notices, it's like you should know that your credit report is not being affected only because you're still there, right? You cannot be locked out. You cannot be thrown out and have your things taken out of the apartment, and the sheriff cannot do anything to you, nor the police. The only way to get you out is to take you to court, right? And only because they take you to court does not mean that your credit is going to be ruined. The only time that you get something reported on your credit report is if you go to jury trial and you lose, right? And like I said, 95% of the cases don't even get that far, right? And the other things that you should know is that when you go to court and you start to negotiate, you might be able to get more time to move out. And in some cases, you might be able to negotiate for some moving money to help you move out and forgiveness of any past due rent, right? The thing that you should know that is on your side is that if you go to trial, right, it's going to cost the owner to pay for the attorney. And that attorney is going to charge the owner anywhere between $7,000 to $10,000 just to go to trial. So imagine if there's 10 of you, right? You think he's going to evict all 10 of you and go to trial for all 10 of you? That's up to $70,000 that it's going to cost the owner, right? So this is why it's important to organize and come together collectively, because if he threatens to evict you all and you all lawyer up, it's going to cost him tons of money. And there's no way that he's going to want to do that. There's no way that they're going to want to spend that much money. They're going to want to settle, right? So you should know that it's going to cost them a lot of money to go through the court process. They don't want to do that. That's why they're willing to give you cash for keys or pay you out, because they know that if you go to trial, it's going to cost them a ton of money, right? So that's really important to know. You have leverage and negotiating power, and you should use it, right? So let's talk about a little bit about AB 1482, right? So, and I'm sorry, these slides are not in English. I borrowed them from another attorney. So AB 1482, as I mentioned, it has the rent caps, 5% plus CPI. It has what's called just cause eviction protections, meaning that they have to have a valid reason to evict you. If you get evicted for no fault of your own, then they have to pay you relocation assistance of 1 month's rent or forgive 1 month. Catherine, you have a question?
Yes, George, I have a question. What's the CPI percentage right now?
In Los Angeles County, it's around 0.7 to 0.9%.
It changed when the pandemic started, right?
Yeah, when the economy went down, so did the rate of inflation. Okay, and also under AB 1482, they have to notify you of all of these rights. So just cause for eviction, these are all considered at-fault terminations. Like, these are good reasons to ask you to move. You didn't pay, you're causing nuisance, you're breaching the lease, you're doing criminal activity. These are all the typical reasons that give property owners a just cause to ask you to move.
Well, I'm sorry, what's the limit or range of causing a nuisance that can be weaponized against tenants?
Yeah, this is not a perfect law by any means. And there's a lot of things wrong with it, like the one that you just pointed out, nuisance. What does that mean? I don't know. No one really knows. This is like one of those areas where you're going to have to go to court to try to fight it, because they might be saying, oh, you're being a nuisance, and the tenant might say, is like, oh, I only turned up my TV this one time, you know. So it's one of those gray areas that is really difficult to define, because no one really knows. And you're right, it can be weaponized to harm tenants. It can be used to try to get them out under this clause. When AB 1482 first came out, there were several lawyers that were defending tenants that were trying to be evicted because of a nuisance, and were able to win in court because it was just, there wasn't enough good reason to evict them under that. So you will have to lawyer up if you're trying to be evicted for that. So these just cause for eviction, these are no fault terminations. So no fault of the tenant, right? So if the owner is going to move in, a family owner, Alice Act doesn't apply to you all unless you have rent control. If there is an order by a government agency, like code enforcement comes and says, oh, we got to shut this building down, you know, it does, like, it's not habitable, then they can ask you to leave. If they're going to be completely demolishing the building, they can ask you to leave, and or substantially remodeling. Remember that a remodeling requires a permit. Exemptions for the rent caps and just cause. So these are buildings that do not fall under AB 1482. So any buildings that were issued, like any buildings that are new, 15 years or younger, they don't fall under this law. If it's a single family house or a condo that is owned by a person, they don't qualify for this law. If it's a duplex where where the owner lives in one of the units, that is exempt. Mobile homes, college dormitories, or low-income housing that is regulated by the government, those don't qualify under this new law. Exempt from rent caps. The only units that are exempt from these rent caps, the 5% plus CPI, are units that are under rent control, and that was adopted before 2019. Other units that are exempt from just cause is like if you're sharing a unit with an owner, or there's local just cause rules that were adopted that were more protective. Dormitories, tourist hotels, nonprofit hospitals, elderly care units, these type of places do not fall under the just cause protections. These are just details, more details. So for example, if an owner occupies one house, like they're renting out rooms and they also live in the house, then that is exempt from the just cause. But if you are renting like a unit that was built, like a granny flat or like they say the in-laws for the in-laws, and the owner is still living there, but they're renting more than 2 units or bedrooms, then you are covered under AB 1482. And then exempt single family homes or condos are normally exempt. They're not covered unless the owner is a corporation or a real estate investment trust. If it's a corporation, then it is covered by AB 1482. This is a little bit harder to prove because sometimes we don't know who the owner of that corporation is or the LLC. And this is what's not exempt is when each room in a house is being rented out, but the owner does not live there.
Jorge, quick
Yes.
question.
Mm-hmm.
To your knowledge, do you know of any way of finding out who does own or is in charge of a particular LLC?
It's really tough.
Okay.
It's what they call the corporate veil, and it's hard to pierce.
Corporate veil?
Yeah, they call the corporate veil, meaning that because you can't get past
I see,
it.
veil, yeah.
Veil, yeah.
Thank you.
George, Tanya wants to ask, so she has a question in the chat. To understand better about the rent increase, my rent is $1,675. How much will the increase be?
Okay, let me see. Let's do the math here. So 1,675 times 5 let's say just slightly higher, 5.9%. So the increase will be $98, $99 maximum in 1 year.
It's almost $100 every year.
Yeah. So the last couple of slides is your responsibilities as the tenant. You have to take care of the unit, take reasonable care, don't damage anything, and if you damage something, you got to repair it. pay rent when rent is due, unless like now you don't have rent, COVID, totally different time. And always, if you're asking for repairs or for the landlord to come into the unit, then you should allow them into the unit, except for right now. During COVID is a totally different time. There's a lot of risks that are involved with being exposed to other people. So right now, depending on your situation, you don't have to let them come in. Normally, if they give you 24 hours notice, you should let them come in, because and then they can claim that you are not, you're not honoring like sort of like the legal terms. But during COVID, totally different. This doesn't apply the same anymore until we get out of the state of emergency, okay? And then again, just don't do nothing illegal, don't commit waste, and don't be a nuisance, and you should be good. So as an organizer, as you all know, it's like when we fight, we win. If we don't fight, we're never gonna win, right? It's like you're only going to get as much as you put into it. And if you don't take any risks, there's not going to be any reward, right? We have to fight for our rights. Like I said, only because the law says this does not mean that they're going to follow it. And so we have to make sure that they are abiding by the law just as much as we are. And we also have to fight for more protections. The only reason we got AB 1482 is because we fought for it and we organized for it. And if you all want local protections in Downey, then you all gotta unite and you all gotta organize. That means go knocking on doors, inviting people to these trainings, inviting people to your meetings, collecting their names and their telephone numbers and their email addresses, so you're constantly in contact with them. It's how you will build a movement. And with your city electeds, like they already are doing right now, they don't like opposition, right? So when we started showing up at the city council meeting, they would get upset and they would call us names, right? Is it because they don't like it? Because they're not used to it. They're used to doing whatever the hell they want and nobody's saying anything about it, right? And so finally somebody is starting to say, no, this is not right. They're going to get defensive. And that's normal that they get defensive. It's like, and while they're there, we have to build our power as tenants and in the community so that we can either get them out and put somebody else in, or force them to do what they should be doing to protect the majority of people in their city and not their own interests, right? So get involved, go to the tenant meetings, share your story. Your story is probably one of the most powerful organizing tools you'll ever have, because there's hundreds, if not thousands of people that are probably going through the same thing that you're going through, but they're too afraid to say anything, or they're too afraid to speak out because they probably think that they're going to be singled out. But if you share your story, you're giving them permission to share theirs. You're inviting them to share their struggle with you, right? So sharing your story, whether it's on social media, on video, at city council meetings, on the newspapers, this is a really powerful tool, because you're going to send a message to people that they're not alone, that you're having the same experience that they're having, right? And so do that and push your elected leaders to do what they're supposed to be doing, and get involved, demand city and statewide policies like rent control, and that'll do it for me.
Okay, to that question, very often we hear from the city officials that it's not within their range of power. Could you explain a little bit what exactly is, or what are the limitations there for the city council?
Well, that's a bunch of BS. It is within their range of power. Cities, Culver City is a perfect example. They passed a 1-year rent stabilization, rent freeze, and just cause temporary, right? And now they're considering it, making it permanent, all right? You can get rent control or any type of law either of two ways, actually three ways. One, the city council can pass it. Two, the city council can vote to put it on the ballot for the renters to vote for it, right? Or for the residents to vote for it. So the city council doesn't have to pass it, but they can put it on the ballot for the voters to vote for it. Or as a community, you can gather the signatures necessary to petition to put it on the ballot and then have the voters vote for it. Those are the three ways that you can get laws passed in your city. So if they say that they don't have the authority or the power to do it, is just their way of getting out of their responsibility to represent the residents in their charge, right? It's not true, especially during COVID. During a state of emergency, all cities have the constitutional power to pass rent freeze and cancellation of rent. They have the constitutional power to cancel rent. So if they say they can't do that, or they don't have the authority to do that, it is just because they don't want to, right? It's like they have that power to do so, and that's why we got to organize. It's like, because they say they can't, because they're listening to other interests, usually the real estate and the landlord interests, and they're not listening to ours, right? And most times we make up half the city, if not more, as renters. So we have to organize and pressure them into doing the right thing.
George, before you finish, I wanted to ask you to give us a little bit about the AB 1436. They're about to be voting for it. I just wanted to invite the people that is in the Zoom meeting right now that tomorrow we're going to be doing a march, protesting in front of the court in LA because of this issue. We need to push for this amendment or new law, AB 1436, which it's gonna evade so many evictions that we call tsunami evictions. And I would like you to give us a little bit of your info from that.
Okay, so what we know, AB 1436 is a bill that is being voted on right now, and if it passes, it will turn into a law. It started in the assembly with the assembly members, and then it went into the Senate. But I think it might be going. So the way laws are made on the state level, it's either there's two sides of they call the aisle, right? You have the Senate, and then you have the assembly. So this is an assembly bill, AB 1436. So it starts in the assembly, and then it goes through all the different committees in the assembly side, and then once it passes the assembly, it jumps over to the Senate, and then the Senate has to go through all their committees, and then they vote for it, and if it passes, then it goes to the governor to sign into law, right? So because of COVID, this process is really, really short now. The end of this cycle is by the end of September. So this law has to pass by the end of August. It has to pass by September, right? And right now it's in the Senate. It went from the assembly, it jumped over, and it's in the Senate, and the Senate is now trying to get it to pass, right? So we have been making phone calls, have been writing emails, have been writing letters, have been doing social media to try to pressure all of our assembly members and our senators to pass this thing, because it will make rent that has not been paid non-evictable, meaning that if you haven't paid rent because of COVID, they cannot evict you for that non-payment of rent, right? And it gives you like 1 year or more to try to pay back the rent that you have not paid. We're trying to make it so that it's forgiven and you don't have to pay it, but at the very least, they cannot evict you for it. If this doesn't pass and and the courts start processing evictions, that means that everybody that has not paid rent because of COVID is in risk of being evicted. So we're talking about thousands and thousands of people, millions across the United States, right? But here in California, it's like tens of thousands of people are at risk of being evicted if this law doesn't pass.
George, we were talking about 300,000 families, the most that is
365,000.
Yes. And another thing, the law from the governor, it's gonna have an end, and it's gonna be at the end of this month. So we gotta be sure that we need to call the governor for him to extend it or do something for that as well.
Right, because even though it passes the Senate and the Assembly, the governor still has to sign it. And if the governor doesn't sign it, then it doesn't go into law, and then it's just a big old mess, right? I have a private message. It's like a lot of tenants pull off their rents or pay smalls. What really the long haul does it mean? How can they protect themselves from getting eviction? I think that's the problem, Michelle, is that we have these protections in place right now, like the Judicial Council Rule 1, which ends on September 1st. And if that ends, then evictions are going to start, right? So we need our governor or our other political leaders to do something now to replace that. If they don't extend that protection at the court level, is like, there's not much that we're going to be able to do except to fight on the streets, right? To defend our homes, to fight against evictions right in front of our homes, right? There isn't much. So if they lift Rule 1 on September 1st and there's nothing in its place, it's gonna be tough times. It's gonna be really tough times. And so that's why we have to pressure our political leaders to do something, to pass something, because it's going to be a lot of people at risk.
Okay, another question. So who exactly is it going to be voting for 1436? The Senate only, or both Assembly members and Senate?
The Assembly has already passed it. So now it's in the Senate.
So it's the governor and the senators that are to be targeted or communicated with.
Right.
Okay, and second, I understand also. Could you are you familiar with was it Ilhan Omar's bill 6515? And could you talk a little bit more about that and why that's not or where it's at?
Ilhan Omar's bill, yeah, I'm not very familiar with it. It's a really strong bill from what I understand, but I also hear that it's kind of just there, that it's not really moving anywhere. And it's a national bill, so it would apply to all of the United States, whereas the ones that we're talking about here are just for California. That's about as much as I can speak on it, because we don't follow the national sort of like legislation. So we don't have a whole lot of intel, or at least I don't have a whole lot of intel on what's going on with that one.
Great, thank you.
Yeah.
I have a question. I often hear from landlords and homeowners that something like 1482 would be devastating for their financial costs. And I just wanted to ask you, are there any valid claims to those statements?
Well, it doesn't forgive the debt, so I don't see how it would be financially impactful. All it says is that you can't evict them because they didn't pay that rent, but they still have to pay it back. It just gives them more time to do so. And I know that when it comes to property owners and homeowners, they have a really strong lobby already. You know, they have the real estate lobby and the landlord lobby. They have the California Apartment Association. It's like they have a really strong voice already. So we advocate at Tenants Together, we advocate for the cancellation of mortgages too, because we don't want people to lose their homes and go into foreclosure. And then we have another foreclosure crisis where all these big investment firms are buying up properties and taking them away from people, right? So we want to avoid foreclosures as well. But we also know that when it comes to tenants and landlords already got a really huge voice. They don't need our help. They should be advocating for themselves. They should be pressuring the real estate industry. They should be pressuring the apartment owners associations to speak on their behalf and cancel mortgages. Tenants, we don't have that big of a voice. So we have to advocate for tenants, which makes up more than 50% of the state of California. You know, more than 50%. So we have to protect those that are most at risk. And that's tenants, which is why we normally focus in on the tenant.
George, and I wanted to clarify that 1436 is going to help house owners too. So it's not only going to be for tenants. We're practically pushing for that law to help the owners for the mortgage be safe, or I don't know how to say it.
It's it advocates for forbearance, and it prevents foreclosures for non-payment of mortgage.
Thank you, George.
Yeah.
So it's about, well, it's already 8. George, do you want to close up? Because I know it's late.
Yeah. So I'll go ahead and let's see, stop share and stop recording.